This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
So the second question I wanted to ask all of you, if you are used to a system where witnesses don't usually come to court and testify and you decide cases based on a written record, the evidence doesn't really change. And you're not called upon to make individualized determinations about whether a single witness is telling the truth or not. So the process of assessing a witness's credibility seems very difficult and almost, to those people who aren't used to it, maybe somewhat mysterious. So you've all had to assess the credibility of witnesses, whether as prosecutors or lawyers or judges. And I wonder if you could talk a little bit about how you go about that process. If from time to time you're called upon to articulate why you find a witness credible, or why you find a witness to not be believable, I think that would be really helpful.
First of all, I do have to say that the process of determining credibility is very, very difficult. It is true. I don't think that's a reason to not engage in the process, because I think it's crucial. But it is hard, meaning at the end of the day, the person deciding on truth and not truth wasn't there when the facts described occurred. And so often one can never know for sure if a witness is credible, is telling the truth, is accurate or not. You are, at the end of the day, making an informed, educated judgment as to what you believe to be the case concerning the witness's accuracy and the witness's truthfulness. It almost can never reach the point of certainty whenever there are contested facts. It's a daunting process, but it seems essential to embark on the process in order to have fairness in a proceeding. So the way I think about credibility, there are a number of kind of classic, I call them earmarks of credibility or factors that are considered. I'll go through some of those. The first, one of the most fundamental questions is the issue of bias, meaning does the witness have some interest in the proceeding that affects what the witness is saying? Classic example would be the cooperating witness for the prosecution who's trying to get a lower sentence. That's a motive. The government would say it's still a motive to tell the truth, and the defense would say it's a motive to exaggerate to help the government. So it's subtle, but it's an important motive. And witnesses have all kinds of motives in cases. It may be that the defendant is an enemy of the family. They have ill will towards the defendant. Or on the flip side, the defendant is a good friend and they're trying to help the defendant. So there are many facets to the question of bias. What is the witness's interest in the proceedings? So bias is always important, but it's rarely dispositive, meaning a witness can still be telling the truth despite having a bias. So it's a factor that needs to be considered. I would say the next factor that needs to be considered is the capacity to perceive the events. So, for example, A witness testifies that he can identify the defendant as the bank robber, as an example. But it turns out that the witness was far across the room when the events occurred. There were many people in between the witness and the bank robber. And so there's just a basic question of how accurate is that identification? I will say that on the issue of identifications, there are just dozens and dozens of cases here, or really hundreds of cases, where there have been false identifications of a defendant. Identifying a person is actually quite hard. Unless it's someone that you've known for a long time, then it's easy. But if you are talking about a person that you're not previously familiar with, it is very hard to be accurate in your identification of that person. There are, particularly if there are cross-ethnic issues involved, it's been shown that it's harder for people to distinguish others of different ethnicities than from their own. So there are all kinds of questions of capacity to perceive and capacity to accurately recount that go into the question of determining credibility. And again, that's not a question of the witness deliberately lying. It's a question of whether the witness is unknowingly giving inaccurate information. The other classic things that we look at in determining credibility are whether the witness has been consistent in what he or she has said, or whether he or she has been inconsistent. In other words, you line up the prior statements that the witness has given on the same subject, and you compare that with the witness's testimony at trial. And of course, if they're consistent, it suggests accuracy and it suggests truthfulness. And if they're inconsistent, it suggests either mistake or intentional deception. Again, these are subtle points, and none really are dispositive unto themselves, but they're part of the factors that need to be considered. Another couple of factors are you want to look to some degree at the witness's prior character for truthfulness. In other words, there are some witnesses who come to court and we know for a fact that they've previously lied. They've been perhaps convicted of perjury in another case, or a judge has found that their testimony was not truthful in another case. Or perhaps they've just led a life where they've done fraudulent frauds that are proven. That's a person whose character for truthfulness is questionable. And you are allowed here on cross-examination to probe a witness's prior instances of untruthful conduct on the theory that if a witness has been untruthful in the past, there's a greater likelihood that they're being, or a greater risk that they're being untruthful in the proceeding at hand. And the last thing, which is the classic factor, is demeanor. How does the witness react on the stand? Does the witness seem evasive? Is the witness not evasive, but direct? That's again something that can only be evaluated in person. And again, it's very inexact. The person might appear to be evasive, and you could draw the conclusion that they're lying, but it might just be the witness is nervous and not doing a good job answering the questions. So these are very subtle questions, but at the end of the day, whoever's making the decision has to put all those factors together and try to come up with a determination of credibility. Sometimes it's easy, sometimes it's obvious, sometimes it's more difficult. I'll give one quick example from my Madoff trial, where the star witness, who I mentioned before, was Madoff's right-hand man. So that witness had led a life of fraud. He had been committing the Madoff fraud for 25 years, where he lied to all the customers. He lied to government regulators. He lied to everyone about that fraud for 25 years. So that is an example where that all came out at trial. When I cross-examined that witness, I went through in great detail all the prior frauds that he committed to show that he was a person of dishonest character. He lied so much he couldn't even tell the difference anymore between the truth and lies. So that was effective as to his credibility, and it's one of the things that goes into the test. What is the witness's prior conduct? Have they shown themselves to be a truthful person or an untruthful person? So those are the main factors that I would look at.
Although it's a difficult process, we have our next two experts are called upon from time to time to make those credibility determinations.
The list of factors that Larry just identified for everyone are very similar to those that we explain to jurors before we ask jurors to deliberate and decide upon the kinds of facts and make the factual determinations that trials raise. And they're also the factors that as a judge, when we write opinions, we look to explain the reasons why we come out the way we do. I would amplify a couple of points that Larry made, and in connection, I think, with capacity, I would point out that something I'm always on the lookout for is a statement that is conclusory. That is to say, it makes an assertion without explaining how the witness knows the fact that the witness is recounting. Because sometimes when that is probed, what you find out is that the witness has drawn an inference from other facts and is now pronouncing a conclusion when you and I might not draw the same inference or wouldn't draw it as conclusively as the witness. And as I was listening to Larry, I was trying to think of a simple example. I hope since I haven't thought about it a lot, I hope it's not too simple. But imagine a witness saying, I saw the defendant rob the store. And then when you press the witness for what exactly did the witness see and observe, well, I heard the alarm in the store go off. I saw the defendant running out of the store very fast with merchandise under his arm that wasn't in a store bag or package. So I saw him steal the merchandise from the store. And then a video is found, and we learn that somebody came in with a gun while this man was online to pay with merchandise under his arm. And when the man came in with the gun and tried to hold up the cashier, the alarm went off and our defendant ran out of the store with the merchandise under his arm. And that's what led the witness to infer that the person was robbing the store, but in fact was not. So another example of where this comes up a lot is I deal with many search warrant applications where law enforcement officers prepare affidavits where they assert certain facts and contend that those facts give rise to probable cause to believe that a certain area will have evidence of crime in it, and I should authorize them to search that area. But if I am dissatisfied with the affidavit and I ask the law enforcement officer in paragraph 4, you say X, how do you know that? You haven't explained to me how you come to that conclusion. Sometimes I get a very satisfying answer and I ask for the affidavit to be amplified, but sometimes I don't, and I deny the application for a search warrant. Larry talked about demeanor and evasiveness. One of the things I look for, and I mentioned this earlier when I was speaking the first time, is how the witness reacts to the lawyer representing the side that the witness is connected to versus how the witness reacts when questioned by the adverse party, the other side in the case. So a witness who is calm and open and responsive to one side's questioning, but guarded and evasive and pretending to be confused and not understand the other side's questioning, has less credibility to me than a witness who is truly attempting to be responsive to both sides. Sometimes when I see a witness giving a lawyer what I think are evasive answers, I will interject my own question, not necessarily to learn the witness's answer to the question, but to see if the witness's attitude and demeanor will change. And if there is a marked change when I ask the question, then I get the sense that the witness is tailoring their answers depending upon who's asking the question, and I lose some confidence in the credibility of the witness. The other thing we always look for, of course, is corroboration. And by that I mean, is there other evidence in the case that ties in neatly with what the witness is saying or not? And particularly in these modern high-tech days where cell phones tell us where people go, and text messages and emails and Facebook posts tell us what people are thinking at the moment of an event, there's often corroboration or contradiction in the objective electronic evidence that can help us determine whether a witness is being accurate and honest or inaccurate and evasive. And so those, I think, are the points I would make in amplification of what Larry's already discussed.
I want to just note a couple of things. Larry mentioned how difficult it is sometimes to make credibility determinations, and how important it is to actually have the opportunity to see the witness, and Steve mentioned to see how the witness responds to questioning from their own lawyer, from the lawyer from the other side. I just want to mention a few things for our colleagues who are practice in other jurisdictions. There are certain features of our system that take into account the value of seeing witnesses testify in person. One is our standard of proof is proof beyond a reasonable doubt. So in a lot of the examples you mentioned, you may have come to the conclusion that the witness was not telling the truth, or you may have come to the conclusion that there's just too much doubt about whether the witness is telling the truth, and the standard of proof would take that into account. The second point is, if you make a credibility determination as a judge and you've heard the witness, in most cases, an appellate court, anyone who reviews your work doesn't really have the authority to change that determination because they haven't seen the witness. They haven't had the experience that you've had. And of course, you all mentioned jury trials, so that we give this decision-making power of assessing credibility in many, many criminal cases to ordinary people, with the kind of instructions that you've talked about. And so with some of those additional points, I want to turn to you, Marty, and you've had a lot of experience and you've often been called upon to make decisions about whether or not you believe a witness or whether a witness is believable. And can you share with us how you go about making those decisions?
Whatever the jurisdiction is, there's a burden of proof everywhere, however it's described. And if there is a real issue about credibility, that's one way in which it can be resolved. The other point I wanted to make, and you began to make this point as well, is that customarily in our system, it's jurors and not judges who are making these decisions. And when I go through the jury selection process, particularly if it's a murder case, any kind of very serious case, I'm going to get one or more jurors who are going to say, I really don't feel comfortable doing this. I don't think I'm equipped to do this. This is too serious for me. And what I tell them is that, there's no special skill involved in determining the credibility of a witness. We do this all the time in our ordinary lives, in big decisions and little ones. People tell us things, and we have to decide whether they're accurate and whether they're truthful, whether it's buying a car or investing in a stock or getting married or much more trivial kinds of decision making. And all the factors that have been mentioned are the factors that I take into account in evaluating credibility, but every one of them requires the application of common sense, and it's a common sense that jurors have and judges have and need to be employed in making these decisions. When there is an inconsistent statement, for example, the question is this an inconsistency about something that is important, or is it about something that's not important? Is it the kind of detail that would be memorable or not? If something is left out in a prior statement that is mentioned in the testimony on trial, is that something that the witness likely would have mentioned in the previous statement? Was the witness's attention directed to it? What's the significance of that particular fact being left out? Obviously, witnesses are prepared all the time to testify. They will go through, whether it's prosecution or defense, the questions they're going to be asked and the questions that they might be asked. They're shown prior statements that the witness has made. And again, the question is, common sense, was this preparation just reasonable given the fact that time has passed since the events in question and the witness's recollection needs to be refreshed? Or is this an attempt to coach the witness into saying things that are not truthful? When a witness is nervous on the stand, is that nervousness because the witness is lying, or is it nervousness because of the situation that the witness finds himself or herself in the courtroom? When a witness is reacting, for example, when being asked questions by the defense differently than when being asked questions by the prosecution, is that evidence of evasiveness, or is that someone who is just indignant at going through the process and angered by the tone or suggestion of the questions on cross-examination? These are all matters of common sense that need to be considered in a common sense fashion. It's one of the odd things about our system that when a defendant waives a jury, and I'm the finder of fact in the case, and I make the determination of guilty or not guilty. In that situation, I'm not obliged to make findings of fact. It's enough to just say guilty or not guilty. And in fact, most judges, at least in New York, when they find themselves in that situation, will do little more than saying guilty or not guilty. On the other hand, when we do decisions in suppression motions and other kinds of motions where there are hearings, in that situation, we do need to make findings of fact and reach conclusions of law. And in that situation, it is important to go through, if you're going to disbelieve a witness, or believe the witness, the factors that lead you to that conclusion, particularly where there is a challenge to credibility in the arguments that are made after the hearing is concluded. And then you go through these factors, maybe not all of them in every case, but the ones that are of particular importance in the context of that witness's testimony, and explain in some detail why you reached the conclusion that you did. It's another oddity of the New York system, by the way, that on appeal in the intermediate appellate court, the appellate division, that while the appellate judges haven't seen the witnesses, they are in a position under the law to make a determination that I'm not, that the evidence is that the verdict in the case, a guilty verdict, was against the weight of the evidence. That is, in a more general kind of way, that they find that a reasonable person would not have found the evidence sufficient to find guilt beyond a reasonable doubt, and they can then reverse the verdict. My review is limited to whether the evidence is legally sufficient, and I would have to find evidence to be unbelievable as a matter of law, which is a really tough standard to meet, in order to throw out a jury's verdict.